to ATN Society Watch. This is a program where we ventilate societal issues, give them aggregate attention with a view to propose solutions that will benefit humanity. And today on Society Watch, we will be talking on industrial actions. We're looking at the legal, economic, other implications of the industrial NLC strike specifically, and their way forward in Nigeria. And on this special interview, we have a legal practitioner. He is famous David, but I will introduce him to you shortly after this break. Welcome back. If you are just joining us, this is Society Watch on Atlantic Television Network, and on this special interview today, we'll be talking about industrial actions. We're looking at the legal and other implications of the NLC strike and the way forward in Nigeria. And our guest for today is a legal practitioner, Thomas David. Thank you so much for joining us.
Thank you for having me.
All right, so we know so much about industrial actions, NLC strike in Nigeria. It is not a new thing, and the issue has really generated a whole lot of controversy. While some say, well, the NLC has all the right to go about their industrial actions, some say that they do not have this right because they are employees and they owe it to duty to their employer to be at their duty post. And so there's been a whole lot of controversy. These are the issues we're looking at today on ATN Society. So first of all, Thomas David, let's look at the legal frameworks backing industrial action, specifically in Nigeria, because like I said earlier during my introduction, we find out that currently in Nigeria we've had series of strikes and all of that, and there has been divergent views as to, is this legal, is this illegal, are they doing the right thing, are they not doing the right thing? So what exactly are the legal frameworks backing up industrial actions in Nigeria?
Thank you so much. I will want to begin by talking about the constitutional framework for industrial actions in Nigeria. First of all, the right to strike is a right that is not negotiable. It is a right that inures in employees, in workers, by virtue of their position as workers or employees. The law is very tight on the right of employees to ventilate their grievances in their various workplaces in several ways. Strike is one of the means of industrial actions. Industrial action is a broader term of it. It could be picketing, it could be cessation of work, it could also be strike. But in this instance interview, we are looking at the right to strike. The word strike itself, from a legal perspective and meaning, as defined by Section 47 of the Trade Dispute Act, entails concerted efforts targeted at cessation of work by employees, particularly in their places of work. The essence of it is to ventilate their grievances in whatever issues that arises and which, displeases them in their places of work. So the right to strike is a right that is both constitutional as well as backed by other legislations of the National Assembly. In Nigeria, there is a constitutional backing to the right to strike. By Chapter 4 of the 1999 Constitution, you will see that this Constitution guarantees the right to freedom of expression as well as the right to join and partake in all kinds of assembly, as long as they are legal and not in conflict with the provisions of the law. Again, the Trade Dispute Act is another very specific legal framework that deals particularly with industrial actions, more so when it has to do with the right to strike. Employees are allowed to ventilate their grievances in their workplaces by resorting to strike, and the right is guaranteed by the provisions of both the Labour Act in Nigeria as well as the Trade Dispute Act. If you want to talk about or look at the issues of where issues arises in terms of workplace environment and safety, then you'll be talking about the Employees Compensation Act. These are specific legislations that borders directly on the right to strike. So the right to strike is not an issue of literature. It is not a privilege. The law guarantees it. As long as the legal provisions are complied with. Every worker, every employee can resort to strike as a way of ventilating their workplace grievances.
All right, thank you, Barrister David. Now, you've talked about a whole lot of legal frameworks backing up industrial actions and strikes in the society generally and then in Nigeria specifically. But let's also look at the responsibilities and rights of these, both the employer right now and the employee in the period of the strike. Now, let's take a cue from the NLC like we're talking about and the federal government. What do you think, because you have said they have the right to embark on the strike, but like I said, there are a whole lot of controversy surrounding it. So what do you think ideally are the rights and responsibilities of both parties during a strike?
Thank you. Let me state first of all that in as much as the employees have a right to embark on strike, there are, however, statutory limitations to the extent they can go. The employers as well have been included with lots of responsibilities during the period of strike. Employees during the period of strike are allowed to stay away from the places of work. They are allowed to choose whatever manner or means that will further buttress the points which they are trying to prove, as long as it does not infringe any law whatsoever. Again, the employees during this period are not expected to resort to self-help. They are by law not expected to take actions which will mean limiting the freedom guaranteed the workers by the law, particularly non-payment of salaries or wages during strike. There is no legal backing to that effect as much as I know. As long as the right to strike has a statutory framework and backing, the employers are as well expected to live up to their responsibilities under the contract of employment. The more reason why the issues of strike come up is because of non-implementation of agreements contained in contracts of employment as agreed between employers and employee. And so if the employers ordinarily lived up to their responsibility or expectations under the contract of employment, the issues of strike or other forms of industrial action would not arise. And so the responsibility of the employer is particularly circumscribed and limited to what is contained in the contract of employment and the provisions of the law. There is no qualifier whatsoever to the right to strike. I will say that and I will say it again. There is no qualifier whatsoever to the right to strike or any form of industrial action. Labor law or industrial law or relations is an internationally recognized aspect of law covered in different international treaties, particularly as it has to do with labor relations. And so countries or states have adopted some of these international treaties bordering on industrial relations. It is as much a human rights, just as the right enshrined under chapter 4 of the Constitution of the Federal Republic of Nigeria, as amended. Thank you.
Now, you talked about this right to cease working within the period of strike and all of that. And you know very well, in fact, one of the precedents that is very recent before us is that of ASU strike, where the federal government invoked the no work, no pay policy. And one of the laws they cited backing up that was the Trade Act of 2005, sections 43, sections 43, where it says that any worker who didn't go to work should not be entitled to the wages.
Very true, I agree with you.
So,
but you see, I think the federal government quoted that particular provision of the Trade Act out of context.
okay, so please.
It is subject to interpretation by the courts. I have been of the view, and I remain of the view, that withdrawal of pay, wages or salary, merely because workers are on strike, is illegal, completely illegal, and contravenes the provisions of the extant laws as it has to do with industrial relations. The federal government, in that instance which you have cited, is, to my mind, obviously misled. Such actions, when subjected to the crucibles of interpretation by the courts, will not stand the test of time.
Now, if you say that such actions will not stand the test of time, we know that the National Industrial Court did uphold that in their ruling against the ASU, in the matter between ASU and the federal government. They upheld that, and that is still standing up to this moment. Those salaries have not been paid.
I agree with you, but the parties who have gone to court have a right to appeal. You know, matters are decided in courts on different grounds. There could be different bases for reaching a decision in any matter before the court. There is a difference between substantive justice and technical justice. And so I maintain my position that the right to strike is immutable. The right to strike inures in every worker, in every employee, and as such, any attempt to reduce the responsibilities of the employer in course of the entire process will be contravening the law.
Now, if that is the case, let's also look at the NLC strikes in recent times. We'll say, in fact, at some point, most people began to feel, well, the NLC cannot embark on a strike because they have been loyal to the federal government and all of that. But we've seen that they decided to, they've been hell-bent, and they went on this recent strike that they just went in 2 days to sound a note of warning to the federal government and all of that. Now, do you think that the processes leading to the strike is instrumental in the success of the strike?
Of course, the processes leading to the strike are quite instrumental to the success of the strike. First of all, administratively, the Nigerian Labour Congress is not a political body or affiliated to any political party, and so they should owe no loyalty whatsoever to any government, be it at the local level, the state, or the federal level. And so the essence, or the whole essence of the formation of the Nigerian Labour Congress as a pressure group is to guarantee, protect, safeguard the interest of Nigerian workers. It is not a political party and should not take any action whatsoever which will point towards that direction. The Nigerian Labour Congress have taken steps to engage in series of negotiation and roundtable discussions with the federal government on this same issue. That is one of the internal mechanisms necessary and incidental to the actualization of the whole essence of the strike action. Trade dispute bargain and negotiation is something that leads to desired results, where it becomes, fruitful. And so the Nigerian Labour Congress have done all of that. They've written to the federal government. They've had a series of conversations with them. We've met with several government representatives, the Minister for Labor, and all the representatives from the ministry and the government. And so, but it is necessary to point out that strike is usually the last resort available to an employee or a group of employees. There is usually the need to exhaust all internal mechanisms, whether stipulated by law or otherwise. Common sense will, of course, tell us that for there to be industrial action, first of all, the both parties should come to a roundtable discussion. There should be conversation, negotiation, where the both parties will have to come to a meeting point. And where the both parties are not meeting at a very convenient point, the issue of strike becomes the last resort. Becomes the last resort. And so to me, I think the Nigerian Labour Congress has sufficiently exhausted all internal mechanisms at their disposal.
You know, if you say that you think they have exhausted all internal mechanisms at their disposal, we know very well that as at 2 days ago, a day before they began the warning strike, the federal government has pleaded for more time. I mean, you talked about negotiations, meeting on the round table, and then if the federal government is pleading for more time to do the needful, but the labor insisted on going on that strike, you think they have exhausted all their options? The
question is, how much time would they need? The issue of fuel subsidy did not happen today. It happened on the very first day President Tinubu assumed office. Upon taking his oath of office, the first thing he did was to remove fuel subsidy, and the impact, the very negative impact of this decision of the president began to tell on all citizens immediately. Fuel stations began to lock up. They began to hoard fuel. You know, petrol price immediately went up. At this point, the Nigerian Labour Congress sent in their warnings to the federal government. They made attempts to have discussions with them on this issue, which they did severally. Within the 29th of May till today is over 2 months, or if not 3 months. What more time does the federal government need to implement some of the things they agreed on in their previous meetings? There is no atom. There is no atom of or even a step at all that has been taken by the federal government to show their readiness and commitment to meeting the bargain with the Nigerian Labour Congress. And so you see, the Nigerian Labour Congress is quite right in my judgment. Besides, this is not you know, an indefinite strike. It is still part of the procedure. We are warning you with this 2-day strike, where you fail to come to terms with some of our problems, some of the issues we have laid before you, we will declare the strike indefinite. So I think the action of the Nigerian Labour Congress is not in any way unnecessary and wrong.
All right. Now, if you say that the actions of the Nigerian Labour Congress is not unnecessary, it's not wrong, let's look at it this way. We've had series of strikes and leaderships of the NLC in years past. In fact, most people strongly believe that the administration, or rather the leadership of Adams Oshomole, pushed the labor in such a way that even the federal government could heed to their demands, and that is not happening right now. Do you think the labor of today is missing out on something? Do you think there's something they are not doing right?
The issue of whether or not they are missing out on something is an administrative concern. The mandate, the core essence of the establishment and formation of the Nigerian Labour Congress should always, at all points in time, govern their actions, their decisions, and their modus operandi. And so the question of whether the leadership is getting it right or not should not arise. The leadership of the Nigerian Labour Congress are governed strictly by the provisions of whatever mandates establishing them. Of course, we cannot overemphasize or even relegate the fact that humans at some point tend to become political. They tend to become political. But there are necessary organs of the body which should serve as a watchdog to call the leadership to order whenever they are derailing. To my mind, I think the leadership of the Nigerian Labour Congress are on the right path. They are on the right path if they continue with this. And I will implore them not to be cowed by all intimidations or any kind of restraints employed by the federal government, just to make them renege and their avowed promises to protect the Nigerian workers.
Well, that being said, let's also look at the legal and economic implications of these industrial actions. Because, in fact, it seems like most people would say that industrial actions is the only language the government understands. So it seems more like every now and then we have one sort of industrial action or the other in the country. So what do you think are the implications of these industrial actions?
Let me say that as long as successive governments continue to be irresponsible, insensitive, and not responsive to the yearnings, the aspirations, the desire and welfare of the people, industrial action will always continue. There will always be industrial actions because it is a right recognized even in the international world. As a worker, as an employee, the conditions of service must be favorable. How can a worker be working from year to year? There won't be any form of increase from time to time to the emoluments, wages or salaries earned by the employee rather. In view of the economic realities of our time, of course, the removal of fuel subsidy has occasioned innumerable hardship on the people. You and I are also affected tremendously. We cannot, shy away from that truth. And so the issue of whether or not there has been or there continues to be industrial actions should be directed to the government. The government is responsible for whatever industrial action that comes up in this country. In Senate climes, you rarely hear about industrial actions because things are done appropriately. So if the government is responsive to the desires of the workers, industrial actions will not come. Industrial actions only come up when the need arises. And the present economic realities of Nigeria at the moment calls for it. Let the Nigerian government be sensitive to the plight of the people, to the plight of the workers. Everyone is affected. A worker who earns 100,000 naira ends up spending over 30 to 40,000 naira before the end of the month on transportation and other sundry expenses. How much does the person go home with at the end of the month? The government must respond positively to these changes. That's my take.
All right, Barrister Thomas David has said if we continue to have industrial actions, if we continue to have strikes in Nigeria, the government will continually be held responsible. We're going to go on a very short break, and when we return, we will talk more on that. Welcome back. If you are just joining us, this is Society watching a fancy television network. And before we went on that break, we have Barrister Thomas David discussing industrial actions, the legal and other implications of the NLC strikes and the way forward. And before we went on that break, he did talk about the fact that if we continue having strikes in Nigeria, the government should be held responsible. And when he said that, I was thinking about how are we going to do that? So that brings me to what legal mechanisms are there through which we can resolve strike issues and maybe, like you said, hold the government responsible so we do not have repeated cases of strikes.
Thank you so much. The issues of strike, like I said earlier, will continue to reoccur. They will continue from time to time as long as the government becomes or continues to be irresponsive to the demands of Nigerian workers. How do you stop these issues? How will the government be held accountable and responsible for this? The employees, as citizens of Nigeria, have a right to vote in all elections. They should cast their votes to persons who have what it takes to manage and cater for their interests. The right to vote is actually a very powerful one, a very powerful tool at the disposal of Nigerian workers. You don't vote leaders who apparently are insensitive to the yearnings of people. You determine who governs you. You determine who sits at the helm of affairs. You constantly put the government in check through public opinion. The ombudsman is there. Of course, the courts is always there. The courts is and will remain the last resort, the last hope of the common man. And so where the actions of the government are inimical to the interest and welfare of the citizens or the employees, in this case, the courts are open. There are channels. The courts are channels through which the workers can ventilate their grievances. The courts can call the executive arm of government to order. The courts can question, reverse, and even declare unlawful and unconstitutional the actions of the executive arm of government. So, the government at all points in time should be held responsible for all ills happening in Nigeria, including industrial actions. The court will remain a very veritable tool, to creating a sane society, to cover some of the menace occasioned by the irresponsibility of successive governments.
Like you talked about the court, going to the court, taking up the issue in court, and the court is going to uphold the rights of the labor unions. But we've seen, I did make reference earlier to that issue between the federal government and ASU. The fact that, first of all, the National Industrial Court said the decision of the federal government on no work, no pay was upheld, and secondly, the ASU appealed that issue, and the decision of the National Industrial Court was still upheld. Now, with all of this, do you still think that the court can actually do anything contrary to the decisions of the executive in favor of the labor unions?
Where the actions of the executive arm of government is against the laid down laws of the land, the courts are there to call them to order. The courts are there to check the excesses of the executive arm. The courts remain committed to upholding the rule of law. The courts remain committed to upholding the laws of the land. Whatever be the case, whatever be the judgment or decision of the industrial court in the past issue, should not and would never deter anyone from approaching the courts. The court at all time is called upon to interpret and to call to order members of the executive arm of government. The National Industrial Court is there for labor-related matters. Of course, there is always room to climb up the ladder of justice. The Court of Appeal and the final court, the Supreme Court. The courts have never stopped in their duty and responsibility to interpret the law as it ought to be.
So invariably what you are saying is that interpretation given to the law with respect to the federal government and ASU issue was the actual thing as stipulated by the law and should be upheld, which is the no work, no pay policy.
I had said earlier that the no work, no pay policy does not have any place in modern society.
But you just said the court will continually uphold.
Of course. The fact that the decision of the court went this way today does not mean that it cannot be overturned on appeal. The courts, like I told you earlier, I said it earlier that there are different yardsticks. There are different bases for reaching a decision by the courts. And so the court will always interpret the law the way it is. But that doesn't mean that if the decision of the court doesn't favor a particular party, you should begin to run into the streets. No. The law is the law. And the courts are there to safeguard the law. Whatever be the actions of the executive arm of government, the courts are always there to do justice to it.
Alright, that being said, are there some legal precedents upon which your arguments can be based? Because if you say that the courts will always uphold the interest of maybe the labor unions or the government, depending on what the law says, and the fact that we have seen some of these rulings even at the National Industrial Court at the level of appeal, we don't know if they are going to go to Supreme, but that is where they are right now, and all of these precedents. How do you analyze that?
The law is always very clear. The interpretation of the courts as to the provisions of the statutes are mere embellishments to the provisions of the law. If the National Industrial Court has said it this way, of course, there is no doubt I do not contest that fact. That at that point is the law. But I am of the opinion that a different interpretation is deducible from the provisions of the law. And when it is tested on appeal, I believe the Supreme Court will not hold anything different from what I have said earlier. There are, of course, a myriad of precedents to the fact that the court is aimed at justice. The court is usually aimed at giving the provisions of the law purposive interpretation. And so I do not see anything wrong in the actions embarked upon by the members of the Nigerian Labour Congress. The court is always there for interpretations of whatever actions in course of their whole exercise.
Alright, so with what is happening currently in Nigeria, how do you think the legal system can promote a fair resolution of industrial disputes, especially between the labor unions and the federal government? And do you think there are any changes that should be done so that we do not have the pattern that we have it already? Because most people are already losing faith in the system.
The independence of the judiciary is one factor that will cure a lot of issues in the system. The independence of the judiciary over time has been argued and upheld to be the only tool and force that can make the judiciary more active. The issues of judicial activism are also there. So the courts should, as much as possible, dissociate itself from politics. The courts should withdraw from political affairs. You cannot marry the courts or the functions or duties of the court with politics. It is usually when persons who are appointed as members of the bench, usually when they begin to associate or affiliate themselves with politicians, or begin to have one interest or the other politically, that's when you see or notice that some of the judgments churned out becomes questionable by members of the public. Of course, as a lawyer, I can never question the decision of the court. But are the members of the public of the same view with me? The way I will analyze the decision of the courts as a lawyer is quite different from how the common man will analyze and see it. Just like today's tribunal, the judgment of the tribunal today, lawyers in various quarters have argued, some affirming and aligning themselves with the decision of the tribunal, others giving legal reasons why they differ with the decision of the tribunal. But as lawyers, one thing is what we hold paramount: the fact that the decision of the court is binding on all and sundry. It is a law. But you see, the system is obviously eaten up by politics. Issues ranging from appointment of judicial officers, payment of salaries and wages, all of these things are determined by the executive. And so the issue of independence of the judiciary comes to light, such that the members of the bench will have the balls enough to dissociate themselves from whatever intimidations or temptations there may be from the executive arm of government. So the Nigerian legal system has a very vital role to play in curing some of these societal issues, and that has to do with judicial activism and the independence of the judiciary. Of course, we cannot take away the importance of legislative powers. The legislature on their own, having been imbued with the power, natural and otherwise, statutorily too, to enact and come up with very fine legislations which will appropriately and better represent and cater for the interests of the average Nigerian worker. Members of the legal profession, those in the inner bar and those in the outer bar, they have a role to play in sending very good legislations or even pushing for the amendment of some which do not, to an extent, represent the interest of the average Nigerian worker. Of course, the law is subject to amendment from time to time. And so I think in these areas, the Nigerian legal system and the members of it, we lawyers, the judges, has a role to play in that instance. And that role is a very important one.
All right, thank you so much, Barrister Thomas David. Now let's talk about you've exhaustively talked about what the judiciary can do, the legal system, and you also made reference to the legislative system. But let's look at right now the labor unions and the government, and what they can do so we can have fair resolutions of labor issues in accordance with the law.
The ongoing facade or fracas between the Nigerian Labour Congress and the government of the day did not start today. They've had interactive sections, they've had meetings, they've had negotiations, and they've come to terms. They've come to a meeting point. As a matter of fact, before this warning strike commenced, there were some resolutions reached between the representatives of the government on the one hand and the representatives of the Nigerian Labour Congress on the other hand. What has stopped the implementation of these resolutions? As I said, there has been a series of meetings, negotiations and discussions between the representatives of the Nigerian Labour Congress and those of the government. What more time does the government need to implement or begin steps towards the implementation of a collective bargain? You see, collective bargain is a very important tool in industrial relations. Of course, during those meetings, the series of meetings between the both parties, there were agreements. Federal government came and said, we shall undertake to increase salaries of workers. We shall provide palliatives. We shall do this, we shall do that. All were mere talks that have not been followed or backed with action. And so the federal government should, on their own part, take steps to implement some of the agreements with Nigerian Labour Congress. At least this will be a very important step towards ending the impasse, the age-long disagreement, or the recurrent disagreement between the government and the leadership of the Nigerian Labour Congress. The government has a role to play, particularly as it has to do with implementation of collective bargain. That's my take on it.
Thank you so much, Barrister Thomas David. He has talked about the federal government doing its best to ensure that the decisions and the orders we reach during collective bargaining are met, and so that we do not have on and off industrial actions in the country. And we also hope that the legal system is going to do their own part, the legislative system, they are going to do their part, and labor unions themselves are also going to do their part. All hands must be on deck, so we have less of the industrial actions and we have swift operations, because of course these incessant industrial actions will keep affecting our system. But this is much we will take on this interview. Thank you so much, Barrister Thomas David.
Thank you for having me.
And thank you, our viewers, for being out there. I am Anita Obari. If you missed anything, you can follow us on our social media platforms: Twitter, Atlantic TV Net, Facebook and YouTube at Atlantic Television Network, Instagram and TikTok at Atlantic TV Network 1. Do remember that peace and unity are the